The 10:30 a.m. docket for Thursday, March 30th, 2023 consists of one case. Appeal number 122472, State of Kansas versus Aaron Douglas Unruh, Marion County, briefs both sides.
Good morning, Your Honors. May it please the court. Darby Van Houten of the Appellate Defender Office on behalf of the appellant, Mr. Aaron Unruh, present and ready for argument.
Morning. May it please the court. The appellee State of Kansas appears by Assistant Solicitor General Stephen J. Obermeyer, present and ready for argument.
Your Honor, that concludes our 10:30 docket.
Counsel, please come forward, and as soon as you get comfortable, you're welcome to come to the podium.
Good morning, Your Honors. May it please the court. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. Your Honors, even when considered through the civil regulatory scheme lens, the liberty and property interests which are implicated under the Kansas Offender Registration Act are so serious that due process requires as a baseline a standard of proof that district courts must clear in ordering an individual to register as a violent offender under KORA. This does not exist under KORA, specifically the section that Mr. Unruh in this case was ordered to register under. Mr. Unruh in this case pled guilty to criminal restraint and 2 counts of aggravated endangering of a child and was ordered to register as a violent offender under KORA pursuant to subsection E1H of KSA 22-4902. This is a KORA statute that defines violent offenders as one's convicted of criminal restraint, except by a parent, and only when the victim is under 18 years old. The Court of Appeals, in reviewing Mr. Unruh's constitutional challenges to KORA, his registration under KORA in this case, found that his interests were not implicated enough to warrant due process protections. This was an error, and they erred in reaching this conclusion for several reasons. First, considering the vast ways in which KORA requirements limit, burden, and increase the risk of serious conviction for offenders ordered to register under KORA, this court's precedent regarding due process requirements, even in civil regulatory schemes, and the current unfettered and burdenless discretion of judges in making additional factual findings under KORA for registration.
Counsel, I'm going to jump in there.
Yeah.
Because the word precedent was mentioned. Are you familiar with this court's decision in Juarez, which was a 2020 case?
Roughly, Your Honor, yes.
I just did a quick word search, or actually my staff did, to try to see if that case was discussed in the preliminary briefings and so on, briefing materials in this case, and we didn't find it. But it strikes me that Juarez, which does not have a majority opinion, it's a plurality, it's a divided court essentially, but it seems to me it's directly on point to this question. So I wondered if you could address how we ought to
Your Honor,
that precedent, which I think is our most recent precedent on this question.
if your question is whether or not, and again, I need to look directly at that case. If I could, I can address it on rebuttal as well. But there were several other cases dealing with regulatory schemes, again, in Kansas that have certain due process requirements as a baseline again. And in this case, again, I'm happy to look at Juarez, but there's other ones that should direct this court's
Fair enough.
consideration in this case. At least, again, there's at this point, I think it's clear specifically from cases, even as the state pointed out, where the Court of Appeals has been split because hasn't been a direct answer on the question of whether or not there should be a certain standard of proof specifically. I think it's clear, and as this court, I don't think there's any argument. I'd assume that there are certain due process requirements in any civil regulatory scheme, even considering KORA as a civil regulatory scheme. And as a baseline, it requires things like notice, an opportunity to contest the court's findings. And again, most importantly, as this court took up in this petition, in this case, a standard of proof that the court has to meet. And again, I'm happy to look at.
Those things have to be delineated in statute, or can they be required as a constitutional overlay, a procedural overlay required?
In this case, Your Honor, I would say that it needs to be required in statute.
Why does the Constitution require that the procedural safeguards of due process be codified in statute?
Your Honor, in cases in statutes that affect an individual's property and liberty interests, this court, the US Supreme Court, has said that there needs to be, when it affects it so severely, a standard of proof.
I agree that, well, at least for purposes of the questions, I can agree that due process protections need to apply. But as I understand it, you're making a facial challenge to the statute itself.
Correct.
And to do that, wouldn't you have to take the added step of saying that the Constitution, that the due process clause of the Constitution actually requires that the statute include a delineation of procedure, which is different from just saying there has to be this procedure?
I think what makes it different, Your Honor, is that what this court has read in to statutes that are silent on a burden of proof, on a standard of proof, is a preponderance of the evidence, and that is not enough. Again, as this court has said, in cases where registration or the effect on an offender, on an individual ordered to register
Would you agree that once we would get into an argument or discussion about what process is actually due, that at that point you're in the world of an as applied challenge as opposed to a facial challenge?
Not necessarily, Your Honor, because again, what Mr. Unruh was ordered to register under in this case, several individuals are, individuals who are ordered to register in any case, and there are several versions, or rather sections of CORA that don't have any standard of proof, that require a finding more than just what someone is what they're convicted under. That's what makes this different. And it's not just Mr. Unruh, it's several individuals. It's every individual in Kansas who is subject to CORA registration orders. At this point, there's nothing that the district court, the state, is required to prove in order to find them or order them to register under. And again, I don't think it's just as applied, because it's criminal restraint. And yes, in this case, that is what Mr. Unruh was ordered to register under. But the statute itself doesn't have a burden of proof, and it requires factual findings from a judge beyond just the elements of the crime. And if the court, or if courts are going to require that, there needs to be some type of standard of proof that the court has to meet as a threshold in order to order them to register. And again, I think that's clear in other cases that the court is aware of. Like you mentioned, there's several ones, or I guess standards rather, that are read into statutes that the court assumes exist. But preponderance of evidence is not enough. There are cases, or I guess rather civil regulatory schemes, such as revoking someone's driver's license, such as taking away someone's child under the sync code, even law licensure, that requires something under due process more than what CORA requires currently at this stage. And CORA implicates liberty and property interests that are more severe and more important, in our opinion, than the privilege of driving a car, the privilege of having a law license. Those civil regulatory schemes require something more than what CORA requires at this point, which I think makes clear that what CORA and the way CORA exists right now is unconstitutional. It doesn't meet the due process requirements. And it's.
Would you agree that in this case, the district court declared or stated at the acceptance of the plea, so at conviction, that Unruh was a required registrant?
They gave notice, Your Honor, yes.
Well, what was that? Notice of what?
Notice of their duty right now, or Mr. Unruh's rather, duty to register
Right,
under CORA
so-
as it exists currently.
Right. And that happens a substantial amount of time before what we've called conditions precedent to the springing obligation to register. In other words, it happened before the fact findings were made.
Yes, Your Honor, but this is different. This subsection of CORA, E1H, as this court has noted, and Miranelli, I believe is what you're referencing, the different categories of registration under Cora. This is not a springing one.
Well, it arises under what we've called conditions precedent, and we've said it can just be purely statutory. In other words, the fact of the conviction, or it can be the fact of the conviction plus some fact finding.
Correct, but
What
that,
I'm driving at is, it strikes me that in this case, your client was declared someone under an obligation to register
he was,
before the fact findings were made. And isn't that a problem?
I don't believe necessarily it's a problem here. I think that, again, it's at least what makes it different, what makes this subsection different is that it's additional elements that are required to be met. So I suppose the answer to your question is yes, it's problematic, but what he was ordered to register under was a subsection of Cora that we are arguing, and it is our position that it's unconstitutional because those additional facts that are required to be met under that subsection are not elements of criminal restraint. The criminal restraint statute doesn't require these other elements of someone being under the age of 18 or someone not being a parent. That's what makes it different. And again, there needs to be some burden of proof. If courts are going to require someone to register under civil regulatory schemes, they're going to make someone subject to civil regulatory schemes, there has to be some type of burden of proof the court has to clear, because at this point, it's unfettered, it's discretionary, and it's covering more people than I think the legislature intended to cover. Especially considering this court's other decisions and the fact that
Were those,
Can I, oh, go ahead.
oh, I was just gonna say, were those facts though, a part of the plea agreement? I mean, and does that affect the analysis in any way? The discretionary findings, in other words, were related to as part of the plea?
I don't believe so, Your Honor, because first, this was a no contest plea, not an entry of guilt. And also more than that, there's no way for someone to agree, for an individual who is ordered to register under Cora to agree to something that is unconstitutional. There's no way right now for an individual under Cora to know what burden they have to, the state, the court has to meet. There's also no way for them right now to contest. Because again, what would they be contesting? It's not clear what type of burden they have to meet or that they're challenging. And to the state's point and their counter petition, it's not the.
May I interrupt before you go to the counter petition?
Yeah.
You said, said something about objecting. What significance is there a defendant's opportunity to object to the finding at the time it's made?
I think the fact, and again, the fact that they have an opportunity to say something to object, as this court and the Court of Appeals and split decisions has said, matters for purposes of notice, for the fact that they know. But again, there's no notice in this case of what the court has to meet, what burden they have to overcome, what the state has to overcome in order to order someone to register. It's not clear what they would necessarily, even if they objected, Your Honor, even if a defendant objected to being ordered to register under this subsection, it's still.
How do you object before fact findings are made? What do you object to?
Well, couldn't you object to the fact finding? Say, I object, and that gives notice to the state that they have something to prove. Hasn't been proved. Or it, if they have the burden, then they would have noticed that you're not acquiescing to this.
And I see I'm out of time. May I answer? Thank you. I think, Your Honor, it's our position, you're highlighting, as well as Justice Rosen, that there's no way for them to know what exactly they're meeting, even if an individual ordered to register under Cora was to object to the registration, to the order to register, that doesn't clear a finding that the statute is unconstitutional. There's again, they could object, but the court in this case, under the statute as it exists right now, could still find it could still find that they meet these additional elements, these additional conditions to register beyond just criminal restraint elements. And there's no right now standard of proof the court has to meet or that the state has to meet in ordering that and making that order. So I don't think that just the fact that they have the opportunity to object at any point before fact finding, after fact finding, clears, makes it or excuses this constitutional violation or the due process failures in this case. Because it's still not clear what the court would have to clear at this point, what the state would have to prove. They could object all day to several things, but there's no, again, at this point, standard that the court has to meet in making that determination and ordering the register.
So it's not the problem that they can't object. It's that if they do object, now what do we do? Who has the burden of proof?
Correct.
The
And
defendant or the state, or what is the procedure? Because you can object to a judge saying or making an erroneous decision right there, saying, I object, judge. I don't think you have a basis for that decision. But then as I see the problem that you're identifying, it is, we don't know what to do after that.
correct. And again, we'd argue that CORA, the subsection specifically in various areas of CORA, violate due process in several areas, but including notice, the opportunity to contest a discretionary finding by a judge, and a burden of proof, standard of proof that the court has to meet in order to order someone to register. We don't believe that any of those are met under CORA right now, but specifically, again, as this court took up in this petition, even if it's just an issue of standard of proof, the fact that if the Supreme Court is going to adopt the Court of Appeals finding that notice is met under CORA, that doesn't absolve the fact that there's no standard of proof, as you mentioned, that the court has to meet, that the state has to meet after a defendant objects, no matter at what point they object. Because again, right now it's discretionary, despite the implications in the property interests, liberty interests that are implicated by CORA. And just to wrap up, we'd ask again that this court find this subsection of CORA is unconstitutional and vacate Mr. Unruh's registration order in this case. Thank you.
Morning, and may it please the court, the state appears by Stephen Obermeyer, Assistant Solicitor General. I did have a chance to look up State versus Juarez, Justice Stiegel, and it does say that failure to provide timely notice of registration obligation does not constitute a denial of procedural due process where the defendant fails to demonstrate prejudice. And in this case, in the appendix to the state's first brief in the Court of Appeals is a tender of guilty plea where the defendant says, I recognize that I have to register as an offender for 15 years. That's in the appendix.
How can he do that prior to the fact finding?
How could he say that he had to register? Well, he should have been able to register at the time of the plea hearing.
Oh, that's partly why I wanted to draw everyone's attention to Juarez.
Okay.
And I don't know that this is an issue that's been resolved by the court because Juarez was sort of a divided court with several different opinions. But there's this question of whether or not once the conviction has been entered, the state has lost its opportunity to generate the conditions precedent which require registration. And so that's the gist of my questions, both to your opposing counsel and to you. CORA itself requires that the court tell the defendant at the time of conviction that he has to register. And that's what happened here, right?
I believe he was told that
The problem, which is maybe even a more fundamental problem than the due process complaints made by the defendant, is that those conditions precedent did not exist at the time of conviction. And we said in Thomas, I'll just read you part of Thomas. Once the opportunity to generate the necessary conditions precedent to trigger the duty to register is extinguished, the failure to make the necessary findings cannot be characterized as an error, and the state does not get a second bite at the registration app. That suggests to me that once the plea hearing is done and the conviction is done, he either has to register as a matter of law at that point in time, or he doesn't. There is no subsequent hearing where we get to make these fact findings.
As you may recall, in this case, it was set for trial on the following Monday, and it was specially set on a Friday to proceed to plea. Unfortunately, the district court judge's judicial assistant was sick that day. She had the paperwork for the registration, and the parties agreed to set this over.
Are they allowed to do that if how I've described the statute is correct, which maybe it's not, but just assume that it is. I guess I don't know why the facts you just described should matter.
I would say that a party could waive a statutory right and agree to set it over at the time of sentencing. And clearly, both sides were on agreement with that. And at the time of
You would agree that court registration is not part of sentence, is not a part of the sentence.
there are cases that say that.
Do you
Correct.
agree that the entire scheme of CORA as a civil regulatory scheme is designed to impose the obligation upon conviction?
Yes, and he got to go between the plea date and sentencing date without having to register. So how is he harmed by that? The fact that he has to register at the time of sentencing, which his attorney agreed to do to set it over. Are we going to call the judicial assistant and drag her out to the courthouse so he can sign the registration paperwork at the time? I don't think that's reasonable. And he knew that he had to register at some point. And in fact, at the time of sentencing, the judge says sentence is imposed, he's granted probation, which he's completed by now. And the judge says anything else.
Doesn't your argument that, quote, he knew he was going to have to register, how does that not lend pretty substantial support to the defendant's due process claims here? And in other words, even just in the course of regular argument in front of this court, there's just sort of this, well, we just know this is going to happen. And that cannot comport with due process.
Well, he was initially charged with aggravated indecent liberty with the child, which is an off-grid Jessica's law. Upon conviction for that, he would have to register lifetime as a sexual offender.
What difference does that make?
Okay, so they work out a plea agreement and say, you need to plead to something where you have to register for 15 years. Okay, we'll plead to criminal
Is all
restraint.
this in the record? I'm just curious, Mr. Obermeyer, is the whole thing about the judicial assistant being sick and that's not in the record?
That's in the record at the time of the plea hearing, Justice Rosen, volume
Well,
9.
the difficulty with the argument you're making about the plea hearing is that it runs straight into this court's precedent in Peterson Beard that says CORA is a civil regulatory scheme and is not punishment.
Okay.
Doesn't it? I mean, in other words, the state can't have it both ways.
I don't see what the problem is that the regulatory scheme gets invoked at the time of sentencing as opposed to at the time of the plea hearing when the parties agree to defer it until the time of sentencing.
Well, I mean, pleas in a criminal case are designed to determine guilt or innocence on criminal charges, not some sort of civil remedy that might be ancillary.
Okay.
It just makes it seem like perhaps Peterson Beard was wrong, which members of this court have said.
I'm not sure I'm seeing what the,
Okay.
I-
enough.
if I can address the procedural due process argument. If you look at the record on appeal, there's more than 25 transcripts in this case. He had several court appearances. He had other cases in front of the same judge. He had a divorce case in front of the same judge. The judge slips and calls him by his first name during the plea hearing 2 or 3 times. The defendant interrupts the judge at the end of the plea hearing and asks, what about my bond? Can I get that modified. And so he's raising issues before the judge to say that he did not have a chance to, raise this constitutional issue about constitutionality of Cora in front of the district court. Strange credulity. The judge says at the end of volume 9, page 29, don't argue with me, Aaron. And he says, I'm not arguing. You're going to get part of what you wanted. I'm willing to drop bond supervision. So that they have this familiarity. I think he could have raised that issue. And and at the time of sentencing, he had the chance of allocution, and he went on for a page and a half, and they argued about conditions of probation, whether or not Unruh could see his own daughter, or have contact with his own daughter as a condition of probation. And the judge said, well, you're going to have to file a motion in the other case, which the judge was the presiding judge on, and I'll decide whether or not you can have contact with your daughter. So I think there's plenty of opportunities for him to raise this argument, and the judge did not shut him off and say, you can't talk about this, or you can't raise that issue. And the parties.
Who has the burden of proof for the civil regulatory scheme application?
For the criminal restraint conviction, it's the state contention that the mere fact of the conviction triggers the registration, and the exception to that, which is what the claim of the fact finding, the exception is by the defendant, because the statute says a person who is convicted of criminal restraint shall register except by a parent, and only when the victim is under the age of 18. And so that's why State Cross appealed the entire issue, that the burden should have been on Unruh to raise that issue.
So it raises a presumption, at least, of registration. Got it?
Yes.
And was there evidence in well, this was a plea. So I assume there was no evidence of whether or not he was a parent, or whether or not the child was, or what the age of the child was.
Well, the complaint alleged that the other two counts, the aggravated solicitation of a child, alleged her date of birth, year of birth, as being 2007, I think, or 2005. And
There wasn't anything in the plea, colloquy.
At the factual basis, the state offered the affidavit in support of probable cause in case 176, and it's a 2 or 3 page single spaced affidavit that set forth the respective age of the victim. So that was there, and that's the other reason that with the except by a parent and only when the child is under 18, how is the state supposed to know if by just looking at somebody, oh, you're a parent? That's really a hard burden to establish, and I think that's why it's an exception if the defendant wants to try and say that he doesn't have to register because it was his child that he restrained, so he's not going to register. He can present that evidence, but it wasn't done because that wasn't the case.
You agree this was a purely judicial fact finding of the parentage?
I don't think there was there shouldn't have been judicial fact finding. I think the mere fact of the criminal restraint conviction required him to register, except by a parent when the victim is under the age of 18. So I think the burden was then on Unruh to show that he fit within that exception.
So the presumption prevailed because it was not rebutted.
Yes. And there were several cases cited that talks about this exception language in a statute that I think the Bennett case and the White case that goes to the general rule that when you have an exception in the statute, the burden is on the person that has to seeking to fit within the exception. And I think in Bennett, in fact, it said you cannot possess a weapon in a school or somewhere unless you're a police officer. And Bennett was arguing, well, the state had to prove that I wasn't a police officer. And the court said, no, that's an exception that Bennett could prove. And similarly, the state would not have to prove a negative that the defendant here was not a parent of the child who was under the age of 21. It just seems to make sense that way. I did file a 609 letter that mentioned a recent case addressing the due process motion Steinert, and there's several Court of Appeals cases, 2 or 3 are cited in the opinion by the Court of Appeals panel here. But Steinert also cites State versus Ford and State versus Ebb, I believe, is discussing the fact that there are plenty of opportunities to raise this particular argument. So unless the court has any other questions, I would ask you to affirm the Court of Appeals ruling. Thank you.
Your honors, just briefly, Justice Stiegel, I'd like to address again the questions you asked both myself and the state. I think you highlight the issue of core that makes this an issue, but what we have raised an issue. Right now, the court can make orders, district courts can make orders for someone to register at any point, pre-fact finding, after fact finding, and there's no standard of proof that they have to meet. There's nothing in the statute that they have to meet. It at this point, under the guidance, under these split decisions like Juarez, there's still no clear way for a defendant whose liberty and property interests are being so severely impacted, which this court has noted, even when viewing it as a civil regulatory scheme, that requires more, that requires something that the court has to meet in order for them to register. In driver's license cases and child native care cases, there's standards again. And to Mr. Obermeyer's point, the fact that Mr. Unruh in this case went to the court and was contesting his underlying guilt, the guilt to the crimes themselves, doesn't excuse or waive his ability to contest or be excused from registration under a civil regulatory act, a scheme that is put in place to put certain civil regulatory conditions on him. There's still certain conditions that need to be met. You don't waive that. A defendant doesn't waive that simply by contesting their guilt. The fact that there is exception language, the word except, again, as we've highlighted in our brief, doesn't mean that it's an exception that the defendant has to prove. These are conditions that a court has to meet, that a state has to prove if they want someone to be subject to CORA, a civil regulatory scheme, according to this court. And the Bennett case, the Ford case, these were split decisions from the Court of Appeals that seriously underestimated incorrectly in our position the implications and misunderstood civil regulatory schemes. The White case, the other criminal statute cases that Mr. Obermeyer has highlighted are criminal punishment statutes with affirmative defenses that is wholly different from civil regulatory schemes. If a court, again, wants to order someone, an individual, to register under a civil regulatory scheme, they have to meet the conditions in the statute. And those conditions have to have a standard of proof that have to be met. And that isn't the case here because there is no standard of proof and no ability for a defendant to contest any finding. That's why we'd ask for this court to reverse the Court of Appeals and again, vacate Mr. Unruh's registration order. And unless there's any other questions from the court, I'd rest. Thank you.
Thank you.
Thank you to both counsel for your arguments today. We will take this appeal under advisement.